Now call the second case on this morning's docket. Case number 115869, Jeffrey D. Kudlasek v. Johnny Shawnee Inc. and Barley's Ltd. I'm sorry, it should be Kudlasek. I think I butchered his name, sorry.
May it please the court, David Morantz and Lynn Johnson on behalf of the appellant Jeffrey Kudlasek. And Your Honor, if I may reserve 4 minutes for rebuttal, please.
4 minutes is granted.
Thank you. By way of brief background on this case, this stems from a motor vehicle collision back on March 10th of 2015. Mr. Kudlasek was driving home from a shift waiting tables, and unfortunately at the same time a drunk driver was headed his direction, and the drunk driver ran a red light at about 70 miles per hour, split Mr. Kudlasek's car in two, nearly killed him. Mr. Kudlasek was in a medically induced coma for 21 days and has fortunately made a good recovery, but he's still impaired by the injuries he suffered on that date. We filed suit on his behalf in December of 2015, knowing that the District Court of Johnson County would very well and very likely dismiss the case pursuant to Ling in this court's progeny on the subject of dram shop liability. We then appealed to the Court of Appeals. The Court of Appeals dismissed the matter on summary disposition in 2016. We petitioned for review to this court, and this court has granted review. And by doing so, we recognize that this court has stepped into an interesting area, both intellectually in tort law, but also in terms of the jurisprudence of this court's prior precedent. And we're ready to talk about that today.
Okay, let's start that. And let me tell you that from where I'm sitting, I understand your proximate cause problems with the common law and the rule. And I got that, and I understand your public policy part. I think it would be helpful to focus on duty, foreseeability, in relation to a third-party plaintiff.
Sure.
Okay? And my first question is, do you have to have the statute in order to establish duty?
That's a good question, and no, I don't think we do.
Okay, then walk through this. I mean, just take this as a typical negligence action and walk us through, without the statute, the duty that you want to impose on these defendants, and then how it's foreseeable that a third-party plaintiff would be injured from the perspective of that defendant.
Sure. Bartenders, purveyors of liquor, sellers of liquor have a duty to the public to prevent drunk drivers from getting out on the road. It's a general duty to prevent harm, a general duty to the public. It's amplified by the criminal statute, or well, we can call it the Section 41-715, but at a baseline it starts with a general duty. The foreseeability of that is similar to the foreseeability analysis that we learned in tort law, that by providing and allowing someone to become intoxicated and allowing them to leave the premises, they can cause harm to a third party. This has come up in other areas of law, in everything from firearms transactions, as we mentioned, to negligent entrustment cases, where the foreseeability analysis has changed from the old proximate cause, very strict analysis, to a more general, broader look at what is foreseeable to the defendant that might happen down the road.
Do you think it's fair to, I have trouble, maybe I shouldn't have trouble, but I have trouble looking at this as a negligent entrustment kind of case. And I guess it's just because the drunk patron is leaving the building, and so it's hard for me to apply negligent entrustment principles to that. Am I wrong on that?
It's a little bit different because you're not entrusting an instrument to somebody. such as a car or a weapon, but you are arming that person with dangerous propensities. So I do understand the distinction in terms of what you actually give somebody, but you are allowing someone to leave your premises who has been inebriated and who is a danger to the public.
The reason I wanted you to take the statute off the table is because it seems to me that if you need the statute to establish a duty to the public, that upends a great deal of state case law in a lot of other contexts. In other words, from an appellate court standpoint, the unintended consequences of a ruling in your favor on that point could truly ripple in ways that would be bad. And talk to me about that.
Well, I think Shirley v. Glass addresses that to some extent. I think Shirley kind of ended the analysis of negligence per se, of whether the violation of a statute such as this created an outright negligence per se claim, but it did state that the violation of a statute could be used as evidence of a duty that was breached. So starting with the general duty, again, I don't think we need the statute to establish the duty here, but the statute certainly does serve as evidence for what a bartender or a purveyor of liquor's duty is.
Now, the purveyor of liquor's duty, you said, is to prevent drunk drivers on the road. That's kind of where you start with this?
As a general concept, I think that they have, it's a broad duty to the public to prevent harm and to prevent a dangerous situation. Specifically, it's more of a gatekeeper function, that these folks are on the front lines of the drunk driving problem, and they have a responsibility to prevent drunk drivers from getting on the road.
I'm just wondering how that plays out for an owner of an establishment. Does that mean that they have to inquire upon entry, who's driving tonight?
I don't think it's
I'm just, how does it functionally work for a proprietor?
It's interesting because my wife asked me that last night.
Yeah, well, that or who's driving? Does that mean there's a drink limit for every patron in that you can have one drink and that's it? How does this work?
Sure, and the reason I mentioned my wife is she grew up in the South and in college and afterwards worked in restaurants and bars in South Carolina and in North Carolina where they had dram shop liability. And they went through training at the time of being able to recognize someone who is intoxicated. And if that person's intoxicated, you ask, how are you getting home? Would you like me to call a cab? Then we talked last night, my wife and I did, well, it's different today. What do you do with Uber? What do you do with Lyft? Technological advances have changed this a little bit, but there is still a duty on that bartender, that server, whoever it might be, to say, how are you going to get home? Do you have a ride? Do you want us to help you out here?
Doesn't that presume that everyone who's legally unable to operate a vehicle lawfully is, immediately recognizable as being intoxicated? That strikes me as a stretching common sense.
Well, and that's why it needs to be, I think the standard should be an obviously impaired or intoxicated person.
Well, that would undermine your initial claim that there's some duty to prevent drunk driving, because above 0.08 is drunk driving.
Sure.
You'd have to install like a breathalyzer at the exit or something like that to do that, wouldn't you?
And we're not advocating that for sure. You start with the general duty, and the duty only comes into play if somebody is obviously impaired or intoxicated. And then it becomes a jury question of what did the bartender, what did the server see? What should they have seen? How did this person present themselves? As Judge Moriarty said in our case, when this gentleman after the wreck tested at I think 0.179, and he was obviously impaired to folks who were at the scene of the collision, he would have been obviously impaired to the bartenders before he left their establishment.
What steps, practically speaking, just following up on Justice Rosen's practical questions, what steps would a bar owner or a bartender be required to take under your theory to stop somebody who's obviously intoxicated from driving away?
Well, I think first off, under the statute that we have, 41-715, that helps establish the evidence of that duty, you cut them off when they become obviously intoxicated. Then the next step is to inquire, do you have a way to get home? How are you going to get home? Would you like us to try to arrange something for you? You know, there is a point, and I think a jury would say, look, this bartender did all they can do. They don't have to shackle the guy.
Yeah, don't have to lock the doors against him, or
Certainly.
tackle him, or whatever.
Certainly. But they have to make an effort. And I think that juries are smart enough to recognize, yes, this bartender, this server made an effort to stop this from happening. So,
Is that how you avoid strict liability? By allowing the defendant to talk about the conduct of the patron in the shop and then whatever policies or practices they have to avoid over-serving?
yeah, I don't think anyone's suggesting there's strict liability for bartenders. And even the old dram stop statutes, I don't think went that far to establish that. But there is an issue of, is the person obviously intoxicated? That's going to be a question of fact that a jury is going to have to wrestle with. And then a jury is going to have to wrestle with, how far did you go? What steps did you take to prevent this person from driving home?
Mr. Moritz, I'd like you to talk about the possible role of the presence or absence of a statute in telling us about public policy and the coordination, if you will, or the healthy interbranch communication about what public policy is as between the legislature and a court.
Because
And
it
that-
seems to me we're in kind of a endless feedback loop on this issue. A statute used to exist, a dram shop statute used to exist. It was repealed and not replaced, and then we got into the act, and now the fact that we've continued so many years saying the same thing and the legislature hasn't acted to reinforce, it's all sort of a self-reinforcing feedback loop.
I think that's a nice way to put it.
I'd like to know, where do we get off the merry-go-round, or
Sure.
are we just stuck on it forever now?
Well, it's going to take an act by this court to get us off that merry-go-round, I think. And going back further, we know that at common law, the judiciary, the courts were not in this area. They did not occupy this area of law because we had no dram shop liability. In the territorial days, the legislature enacted a dram shop statute. They stepped into the area of law. That statute stayed on the books until 1949, and that's been mentioned in the briefs. And then that statute was repealed, and it opened up this area of law. As we argue here, I think under basic causation and foreseeability principles, this is an area of law that this court is well equipped to step into. It can craft standards of behavior. But this court, in its prior rulings, has said that the repeal of the old dram shop statute has been evidence of legislative intent, that the legislature doesn't want dram shop liability, coupled with the failure of the legislature to really address the issue at any point since then. So if we start with that repeal of the law, it was not a deliberate decision that the legislature made to just get rid of the old statute and then not reimpose it. That statute was repealed with a host of other statutes when the Kansas Liquor Control Act was enacted.
So
It
wasn't targeted, is what you're saying.
Exactly. It wasn't targeted. Everything was off the books. The entire field of law was cleared to make way for a new set of statutes. And I kept wondering, okay, well, why'd that happen? Why wasn't dram shop mentioned? And I looked in the Legislative Journal from 1949, saw nothing. I called the Legislative Research Department to find out if I could get committee testimony, any sort of evidence of that. Nothing, because they don't keep it prior to the 1960s. I went over to the State Library and went through old Browning newspaper clippings and tried to read about what was happening in the 1949 session. It was quite interesting, and as you can imagine, at the time, Kansas was fiercely dry. And so this was a pretty big step to take, and one political writer wrote about it that the bill that they were considering emerged by compounding a magic formula. To please the wets, liquor will be made legal. To please the dries, drinking liquor will practically be made illegal. And what you had was a system of statutes that basically meant you could only drink in your house. You had to go to a package store to buy it. The liquor was sealed. If you were pulled over on the road with the liquor not sealed, you got busted. You couldn't buy liquor at an open saloon. Open saloons were outlawed. So all you could do was drink it at a private club where you had to bring your own booze, or at your house.
Sounds like marijuana in Colorado.
That's a topic of another discussion, sure. There was no dram shop liability because there were no dram shops. We closed the open saloons. We didn't have a need for this. And one of the law review articles that we provided you after the briefing, the Washburn Law Journal article, cited an Indiana Law Journal article from the 1960s. In that article, and I can provide you the site if you're interested, noted that a host of states at the time, when they brought back comprehensive liquor control acts, did not impose dram shop liability. It had kind of fallen by the wayside, and no one mentioned it. And that site well, let me provide that in my rebuttal so I don't burn up any more time. The second part of your question, though, Justice Breyer, is what about then since 1949? Why hasn't the legislature done anything? And this gets into that murky area of trying to divine legislative intent through legislative inaction or silence. And I think that courts go down a dangerous road when we try to say that because the legislature didn't do X, it means Y. Some of the Supreme Court writings on this and the Law Journal writings on this refer to cases as the dog that didn't bark, off of the Sherlock Holmes story about the racehorse who was guarded by a dog. Sherlock Holmes discovered that the night that the horse went missing, the dog didn't bark, therefore it happened at another time. This is not a case, I'm going to argue, where this court's rulings in Ling and in Bland and even the Court of Appeals ruling in the Noon case, this is not a case where the legislature was required to bark. What this court didn't prompt them to do anything. Instead, we're left in an area of we're trying to figure out legislative intent from a very murky political process. And Justice Scalia was a longtime opponent and critic of that type of divining of legislative intent. He wrote that it could be a host of reasons why the legislature didn't do anything. It might not be an endorsement of the status quo. It might be indifference. It might be unawareness. It might be simple political cowardice.
We know it wasn't completely indifference or unawareness because there were efforts to reenact, and so it's somewhat the legislative silence is somewhat polluted by some noise, right?
It is, and I think though that illustrates in an area of this nature, in an area of pure tort law and causation and foreseeability, which is really what courts do, to try to figure out why the legislature did something in that area, and then to say that because they didn't act, they endorsed the status quo. I don't think we can go that far.
I think maybe your best route out of the feedback loop is to just say this is the court's job to do tort law.
It absolutely is.
Rather than, and do kind of an institutional competence argument, as opposed to a total silence doesn't mean they are making a judgment. It just means silence, because they're not totally silent. There just hasn't been the political will to get a dram shop law enacted for whatever reason.
Well, and we don't even know if it's a lack of political will or a breakdown of the political function.
I'm using that as a kind of a catch-all for all the things that can befall legislation.
But it illustrates the problems in that area of trying to figure out why they didn't do it.
Okay.
And I'd argue this
I
court.
take it another way to characterize what you're saying is legislative intent one way or the other is completely irrelevant because what you're here asking for is a common law rule.
That's the starting point, yes. And if the court, as an alternative, if the court does think legislative intent is in the game, I'm arguing we can't divine that through what's happened across the street since 1949. Now, this is an issue of standards of law, standards of tort law, which is right in this court's wheelhouse.
Well, if this is a question of common law, that has nothing to do with legislative intent. You're asking us to change what has been a longstanding rule of common law.
We are.
And so real briefly, how do you meet the tests that we say we look to change longstanding rules of law?
Well, we go back to an old immunity that was based on a causation analysis. And that causation analysis has fallen out of favor. It's no longer really recognized by courts, we go to more of the foreseeability analysis, as I mentioned.
So that's number one. I mean, we basically have three things we'd want you to address if you want us to change a longstanding rule of common law. Number one is that either the rule was originally erroneous or that it's no longer sound. You're saying it's no longer sound.
Correct.
So that's number one. I'm just trying to expedite because you're out of time. Number two, that more good than harm will come from changing it, which I haven't really heard you address that much, except maybe a little bit in the beginning with the Justice Biles question, and then finally the public policy argument.
Sure. And I think 2 and 3 in this area kind of get melded together. You know, that more good than harm is going to come from changing this law because it'll help reduce drunk driving. We can argue about the stats and the studies, but I don't think there's any doubt that imposing a duty on bartenders is going to help keep more drunk drivers off the road. And there is a public policy in favor of cracking down on drunk driving. I don't think that's in dispute. So again, in an area of tort law like this is well within this court's power to change that old common law immunity. And as we mentioned in our briefs, this court has undone and abolished common law immunities in the past.
Is it a better public policy to just say that we should be comparing fault among people that breach a duty and potentially are claimed to cause harm?
Well, in fact, that is the public policy as evidenced by the legislature through 6258A, where the fault of all wrongdoers is to be compared. And for whatever reason, through this kind of strange feedback loop, as Justice Byers described it, we're in a position now where the court and the legislature somehow have carved out an exception for liquor vendors from that comparison of fault of all wrongdoers. They're the only folks who are immune from this. And that's a mystery. If there are no other questions, I'll...
Any more questions? All right. Thank you, Councilman.
Thank you.
Good morning, Your Honors. John Bursch on behalf of Johnny Shawnee. I will be dividing my time, 10 minutes and 10 minutes with Mr. Thompson on behalf of Barley's. May it please the court.
Counsel, good morning and welcome.
Good morning.
I have a question for you.
Please do.
Some of our precedents talk about how we just can't have this rule, meaning dram shop liability, as a matter of tort law, because it would be so hard. It'd just be so hard to figure it out. The scope and who qualifies and who doesn't and what kind of drinker would be included, etc. It's just so hard. But we do hard stuff all the time. That's basically what we're here for. So I'd like you to address that.
I will, and then I very shortly after that want to address Justice Biles' point about
Certainly.
duty.
Thank you.
This is hard, and not just for the reason that Justice Stegall mentioned, the difficulty in identifying whether a person is so intoxicated that they're dangerous to be behind the wheel, because you've got to figure out what the standard of care is, what the duty of inquiry is.
So there are practical difficulties for the liquor provider.
But far more than that,
Yeah.
how you deal with the bar hopping scenario. How about where the bar hasn't actually served a patron any alcohol, but they appear to be inebriated when they walk in the door? Other states with their statutes draw lines based on minors and non-minors. And then what do you do with other social situations where you have dram shop type situations, but not an actual bar? What about the social gathering? What about employer parties? What about fraternities and sororities? One of the amici briefs mentions the appellate judges who serve as bartenders at the after party of the Wichita Bar Show. I'm from Michigan. I would love to see what that bar show is all about. What about the injuries of the intoxicated driver? Can they recover from the bartender? Would it also include intentional torts that person commits when they go outside and they assault somebody in the parking lot? The EMS amicus brief suggests that this could even apply to domestic violence.
So what happens in other states where there is dram shop liability? All these things that are so hard that you're mentioning are dealt with, aren't they?
Almost exclusively.
Why is Kansas only one of 4 states that don't have this?
Justice Rosen, almost exclusively by statute, because the legislature looks at all the data, they take testimony, they look at every possible permutation, and they draw the lines by statute, which is exactly what this court suggested should happen in Kansas.
And for example, in Alaska, that court set the, changed the law to say that there would be liability, reversed its longstanding practice. And at that point, the legislature came in and connected some of the dots and solved some of the issues that you've raised, right?
That's true that was the precipitating event in Alaska. But I will tell you that that's a very rare event. In fact, virtually all the states that have done this have done it by statute. And the reason, Justice Biles, is to go back to your initial line of questioning. And that is, where do you find the duty in Kansas tort law? And my friend, Mr. Morant, says, well, a tavern owes a general duty to the public to prevent harm. Now, I want you to think about how broad that statement is, because that duty has never been specified in Kansas law. To date, the duty has been to the patrons on the premises. Once they go somewhere else, the duty doesn't extend. If there's a duty to keep someone who's drunk from getting behind the wheel of the car, there's also a duty to keep a patron who's too sleepy from watching the KU game until midnight from going out and getting in the car. There's also a duty to stop the patron who's angry and might go out and have road rage and hurt someone. And it wouldn't stop at bars, because there's nothing special about restaurants or bars when you're talking about a general duty to the public. If I'm a kitchen store and I sell knives and someone comes in and suggests that they might use that knife to harm somebody, well, if I've got a general duty to protect the public as a proprietor, then I also have to stop that person from buying the knife and going outside of the store. And really, why should it stop at businesses? If I'm a family member and there's an elderly member of my family, say it's my grandmother, and I know that she's really gotten to that age where she's not safe on the road anymore. She goes too slow, she doesn't notice things, she can't react quickly. Don't I have a duty to stop her? Yeah, the reason, Justice Biles, is that Kansas, just like all the other 49 states, has never enacted or followed a rule that there is a general duty to protect the public. You have the duty to protect the person in front of you.
This is what I wrote down a couple of weeks ago when I was going through this stuff, and I want to know if this is a true statement. Under current Kansas law, a vendor can continue to serve an intoxicated customer and know that customer is going to drive, and the vendor will never be liable. Is that a true statement under our current law?
I think that is a true statement under
How
current
does
law.
that make sense?
Whether it makes sense or not civilly, the backstop to that, Your Honor, is the criminal policy. And that's Kansas Statute 41715. That is not a basis to impose civil liability. Let me be clear about that, because a separate Kansas statute says that any Kansas statute to create a private right of action must do so expressly. That's 60-5201 sub B. But that criminal statute imposes severe penalties on that bartender who continues to serve. They go to jail. And so the Kansas legislature, in its wisdom, has already decided that, at least for now, this is how we're going to deter the drunk driving problem in Kansas. And you can look at the stats. There's lots of these in the amici briefs. And generally, across most categories, Kansas is right about average, or even a little bit better than average, compared to the states that have dram shop civil liability. And perhaps that's because a $100,000 damage award against me is nothing compared to having to go to jail and to lose my liberty. And the Kansas legislature has acted in this area. We have the supplemental letter that Barley's filed, where even just in the past 2 years, the Kansas legislature has enhanced the laws that we have to try to stop this kind of conduct. So it's not as though they're not taking action. Plaintiff's complaint is that they haven't gone far enough. And what they're asking you to do is to reverse that.
Why should we care what the legislature's doing here? I understand why we care, perhaps, when we talk about policy, but just as a pure question of rendering a legal decision, why does what the legislature's doing or not doing matter?
Because if there isn't a common law duty...
Well, that if the question is the common law, then this court has the ability to go a different direction.
You do. But when you're talking about a general duty to prevent harm to the public...
Well, I understand all the arguments why we shouldn't go in a different direction. I'm asking, why should what the legislature does be one of those arguments?
This is why. Because you follow, as part of your doctrine of stare decisis, the theory of legislative acquiescence. And so where this court, over a period of 30 years, has acted in this area 8 separate times.
But let me just cut you off. And
Yes.
I mean, legislative acquiescence, we normally think of that as being when we have interpreted or construed a statute and the legislature has not acted to correct, quote unquote, our interpretation. That's acquiescence. But I don't know of a situation where a court has applied the doctrine of legislative acquiescence to a common law rule.
I don't know that you have. I'm not aware of a
Well,
case.
does it make sense?
But
Does it
certainly,
make sense to apply it in that context?
I think it's broader than that. In Quested, the case that you decided in 2015, page 16 of our brief, the way you stated this rule is that stare decisis is particularly compelling when the legislature declines to respond to court decisions. So over a 30-year period, when you say, legislature, this is your ball, not ours. Legislature, this is your ball, not ours. We're not going to act, you have to act. And then they don't act. The legislature has sent a signal to you that this is an area that they're going to regulate by other means, through criminal penalties on bartenders and bars, and through all kinds of other things. And really, to go back to Justice Beyer's initial question, Justice Stiegel, the regulatory framework around this that you would have to write from the bench is extraordinary. I mean, Mr. Morantz was talking about how down south that this training that takes place so that bartenders can tell who's drunk and who's not, who's impaired. That's by statute. You know, is this court going to write in its opinion under the common law what that training should look like, and who has to take it and who has to follow it? It's really ludicrous. My time is winding down, but I would remiss if I didn't make one important point in addition to stare decisis and legislative acquiescence that goes along with this separation of powers principle that we advance in our brief. And that's the policy argument, or the policy against the retroactive application of a change in law. I don't think anybody could dispute that if you would reverse Ling and Bland, that you would be creating a new rule of law. There's no question about that. Retroactive application would not further the principle on which the decision is based, because what I'm hearing from everyone and what they say in their briefing is that the purpose of enacting this by common law is to stop bartenders and bars from serving intoxicated patrons. Well, we can't change the past. That would best be done prospectively. And finally, there would be a substantial hardship and injustice on any business which is still within the statute of limitations, which likely doesn't have insurance, may not have trained its bartenders adequately, and any other numerable things, could not have predicted that this court would go back on 8 precedents in the last 30 years alone and the legislative silence. Unless there are any further questions, thank you so much for your time.
Just so I'm clear, to summarize one of your points, the legislature has accepted our invitation to take care of this issue, but they're just moving very slowly, i.e. the criminal penalties.
I would say it's just slightly different, Mr. Chief Justice, that the legislature is acting in other ways than what the plaintiff and the plaintiff's bar would desire. They have put other policies in place to try to deal with the problem of intoxicated drivers. They just haven't imposed civil liability on restaurants and bars. And it may be that the policy that they have now, they decide is working. And if it is, then it's not this court's job as a separate branch to disrupt that.
All right, thank you.
Thank you.
Any further questions? Thank you, counsel.
May it please the court, Todd Thompson on behalf of Barley's Limited. The discussion on the policy is on the wrong side of the street. It needs to be on the other side of 10th Street. That's where this policy needs to be debated, and in fact has been debated virtually every session for decades.
When we shape common law, don't we weigh policy considerations? Isn't that very traditional in the history of American jurisprudence?
You can venture into changing common law, so let's talk about why you would do that.
You started by saying we shouldn't consider policy, and I'm just asking
I don't think
whether the courts traditionally consider policy when they fashion rules of common law. It seems to me they have to.
I think this is a policy issue that should be handled by the legislature, and you're correct that common law can be changed by the court, So what are the changing circumstances here? If you go look at the briefs, they're not identified by anyone.
Well, one of the changes is the legal one, the shift from kind of a pure proximate cause oriented tort law to comparative fault. Are you just saying, well, we've had precedent since then and we haven't changed it?
We've had lots of comparative fault precedents since then.
Okay.
We have
How do we tell the difference? I mean, isn't the distinction my colleague has mentioned between tort law and other kinds of law that is driven by statutory enactment, isn't that distinction important for drawing the line between public policy the court speaks on, got it on the wrong side of my imaginary line, public policy the court speaks on versus public policy we leave to the legislature? Isn't that where we draw the line? And isn't the fact that we are in common law land, that we're in tort land here, isn't that dispositive about whether the court can express an opinion on public policy?
The court can express an opinion on public policy.
By making a rule
I don't
that
think that's
recognizes-
been debated at all here. I don't think that's the issue. The question is, should you in this instance?
And how do you tell the difference between should and should not?
Well, why is there a change? Why should there be a change? You're being asked to make a material, significant change and to maybe not ignore, but overcome the beneficial effects of stare decisis. And yet there has been no compelling change of circumstances identified for you.
Let me talk about that for a second, because the rule you want to stay married to is Old English common law from the time of Blackstone. And it occurs to me that the kind of trouble that a drunk patron in a bar in England at the time of Blackstone, that the amount of trouble that a drunk patron could get into walking out of that bar is a lot different than the drunk patron that gets into an F-150 and heads down the road today. And doesn't that enter into the common law analysis that we need to do? Because the roots of what you're talking about are before the days of cars, even. So why do we stay married to that?
Well, I don't think that's what we're, quote, staying married to. We're staying married to this court's rulings and the prior considerations of this court.
But all of that was based on Old English common law. I mean, that's the thing that's been gnawing at me. And, and all of this started with, I think it was the 1949 case where the guy that was drunk that banged into his bootlegger, and the bootlegger sued him, and he said, "You can't sue me because you sold me the moonshine that got me drunk when I ran into the back." And the court said back then, well, let's just look at this Old English common law and apply the principle. It seems like things are different now.
Well, there were F-150s when Ling was the opinion of this court. There have been F-150s, I think, for most of my lifetime. So I don't think that is a material change in circumstances. But I tell you what has changed. We have now a legislative action to shun drunk drivers. Society has changed and shuns drunk drivers. The legislature considers and refines penalties each and every year. And the KTLA brief itself says that those changes, quote, have certainly been effective. They say that on page 3. And that's what we know. We have a declining number of alcohol-related traffic accidents each year. The trend line is going in the correct direction. So the question becomes, what has changed in the past 10 years that would cause this court to abandon its prior rulings and jump into the fray that the plaintiff has asked you to jump into? Or would it be better to have this matter continue to be considered across the street, where there can be a much more detailed analysis and lots more facts presented? That's what we're asking you to do, is let the legislature continue to deal with this issue as it has been and has been successfully doing for the past 15 or 20 years.
Counsel, can you foresee a circumstance in which this court should get involved?
In any matter, or you mean in dram shop issues?
This issue that brings us here today.
Sure. If the legislature ceases to consider these efforts to reduce drunk driving for the next 20 years, and you do see an absolute lack of attempt, perhaps the court should step in at that point on this common law issue. But that's not the situation
I don't
we
understand.
have.
I guess, counsel, I don't understand that answer, because I'm back to why does what the legislature does weigh? Why should it weigh our consideration of common law principles and what the common law rules should be in this state? It just strikes me that that's an independent duty on this court.
Well, I think that ignores the historical context that
Well,
we
I
have in
understand that
Kansas.
there's lots and lots of arguments as to what the common law rules should or shouldn't be. But I don't. Your answer just a minute ago to the chief was, yeah, we would be justified in changing the common law if the legislature somehow abdicated its so-called responsibility, and I just don't understand that answer.
I said that there might be a situation where the court might step in.
Well, that's what he's getting to. If you can foresee any situation that involves the legislature, then haven't you really undercut?
I think the court is most at risk of losing its judicial credibility when it steps in to a matter that does not have cognizable roots in the Constitution. And so I'm not sure why you want to step in this, would want to step in this particular instance.
But tort law isn't rooted in the Constitution. Tort law doesn't come from the Constitution. Tort law is common law.
Well, the
I mean,
remedy,
Constitution is a discrete source of law from the common law. So I don't understand that. Can you?
the remedy.
I get it if we're dealing with a constitutional question that we would want to be wary of wading in where the Constitution cannot be read to justify a decision. That makes perfect sense to me, and I get that ongoing controversy, but I don't get that on common law at all.
You don't get why.
I don't get the judicial credibility argument on common law. Common law is a judicial creation, and we maintain it, and that's what Justice Stegall keeps asking about. So I just want to understand the constitutional argument.
I have half a minute left. Does anyone have additional questions?
You don't have a response to that?
Well, I'm not sure I understand your question, Justice Byers.
Okay, let me try to rephrase it. You said that we lose judicial credibility when we stray from the Constitution. And I'm asking, as Justice Stegall asked about what does it matter what the legislature says, I'm asking what does it matter about the Constitution when we're doing common law?
I believe that the court should, on matters that are being addressed by the legislature, defer to that legislative process. And that in this instance, the legislature is addressing the issue of drunk drivers and has been for a number of years now and has been doing so successfully. So in that instance, that policy issue should be handled in the legislative process.
Do we have any further questions? Yes.
Just briefly, as my colleague had asked other counsel, we typically have three questions we ask when we're talking about stare decisis. And the first one is that either the prior decision was just erroneous, or there's been a change in circumstances. And what I'm hearing you say is that we have this period, or recently, probably even longer than recently, the legislature has mounted an attack on drunk drivers, has endeavored to increase penalties and that sort of thing, as you argued. Why isn't that scenario or that atmosphere a change that would support that first question we ask on why stare decisis doesn't mandate the result?
Well, your test is whether the rule that exists is no longer sound because of a change of circumstances. I would say the big change started in 1949, and the rule that's been in place since then is still sound, and allowing the legislature to handle the issues related to alcohol has been working. So there is no compelling change of circumstances that show the rule is no longer sound. The rule is still sound.
Any further questions? Council, we've used some of your time with our questions. Do you need 30 seconds to wrap up? Do you think you've made your points?
I think this matter has been extremely well briefed, well argued, and that the court should have enough information to affirm the ruling that's before it.
Thank you, Council. You reserve 4 minutes for rebuttal.
To clean up my earlier record, I do want to provide that cite to the Law Journal article that I mentioned very briefly. It's 37 Indiana Law Journal 317 from 1962. And again, that was regarding states largely abandoning the old dram shop statutes when comprehensive liquor control acts came into fashion. I want to cover some of the hypothetical scenarios that counsel mentioned at the outset of the
Before you do
argument.
that, will you go back to a real basic question for me?
Sure.
Your opponent, your first opposing counsel who stood up, said that he kind of articulated the duty that you're asking us to recognize, and he articulated it very broadly. But it struck me when he said it that it was an accurate recitation of what you had said in your opening argument. So if you would just articulate for me the duty you're asking us to recognize.
That there is a duty by sellers of liquor to prevent, it's a duty to the general public, to prevent drunk drivers from causing harm to the general public.
Okay, thank you.
And the theoretical basis for that is that the public policy has been stated by 41-715.
I think that's evidence of it, but at a baseline, we're all under a duty to prevent harm from folks and to not create harmful situations. So if we broaden it that much, that there isn't a very broad duty to prevent a dangerous situation.
Stated that broad.
To third parties.
Yes,
I mean,
yes.
the basis of extending it to a third party is, what are you resting that on?
I think we all have a duty to prevent harm to others. And whether that be through providing alcohol to somebody or negligently selling or transferring a firearm, negligently entrusting a vehicle, that's a duty that tort law places on all of us.
I don't get the negligent entrustment theory here, to be honest, because it seems like what's being negligently entrusted is the entire world the minute the person walks out of the bar, and I don't get that.
Well, and I mentioned negligent entrustment as a situation
An analogous
where law imposes on us a duty to prevent harm to third persons. I'm not so much analogizing the provision of liquor to a negligent entrustment claim.
Okay.
Did you have a question, Justice Stevens?
I've got one. I know you've
Sure.
got notes, and I don't want to get you off your rebuttal, but I do want at some point for you to address Mr. Birch's citation to 605201 sub C, which says courts of this state shall not construe a statute to imply a private right of action in the absence of such express language. Seems to me that ties right to the heart of the, what is it, 41-715 argument that you've made.
Sure, and that was, I think, a 2012 law that the legislature adopted, so it's relatively new. And to my knowledge, I don't know if it's been annotated yet in the books. We're not stating that 4117 creates a private cause of action. Again, it comes back to what this court has said in Shirley v. Glass, that statute is evidence of the duty that is imposed on purveyors of liquor. So the violation of that statute can be used to prove that there was a duty and to show the violation of that duty. But we're not claiming that that statute alone creates a private cause of action here. To briefly address some of the hypotheticals that counsel mentioned early on about providing somebody a knife, or I think there was allowing a tired grandmother to drive home, if I heard correctly. In each of those situations, if harm is done to a third party, there would be liability. But when it comes to alcohol, for some reason, it's alcohol and only alcohol, there's no liability. And that just doesn't make sense. This court has been very patient with the legislature. For 30-some years, it has been patient, hoping that the legislature would do something. And this court need not wait on the legislature, because this is an area of common law. And it's time now come to do something about it.
If we agree with you that it's time now to do something about it and adopt your position, what should we do with the concern of what happens to present-day proprietors who have not planned for this change to occur? How would this decision impact them, or what should our ruling look like as it pertains to that?
Well, as we pointed out in the brief, we get into the generally a change in a rule of law will be applied retroactive unless you have the factors under the Chevron test for prospective application. I don't think that all the factors of Chevron are met here, because specifically that the third factor of whether retroactive application would cause substantial hardship or injustice. The bartenders have always had criminal responsibility and faced criminal liability and penalties for serving an obviously intoxicated person. So we're not putting any new hardship on them. And we did not have the chance to do discovery in this case,
Right.
But I'm fairly certain that these bars, and most bars, probably have procedures and training where they tell folks, don't overserve somebody. So I don't think we're imposing any new hardship on them.
Counsel, your answer to the hypothetical about the kitchen store owner who sold a knife is intriguing to me. You said there would be a cause of action. Is there a difference between, as a common law matter, between saying there is no cause of action and just saying that the intervening bad act, as a matter of law, cuts off liability? Is there a difference between those two things?
Well, it's a good question. I think under the old common law analysis of...
Well, we're in common law land. I just want you to assume, for the
Sure.
purpose of my question at least, that it's
Sure.
just pure common law.
I don't think that sort of strict proximate cause or severance of causation analysis still applies anymore. We're in tort laws moved to a foreseeability analysis. And specifically 6258 says all wrongdoers, and it doesn't sever that causal chain at any point in time. Now, there's a difference between a cause of action and a meritorious cause of action.
Right.
Right.
If we provide a knife to somebody, you might be able to file a lawsuit, but I don't think you're going to win.
You just can't win because, as a matter of law, there's an intervening superseding cause that's going to cut off liability.
Yeah, we may call it that or something else, but that's...
Yeah, I think, I don't know if it's intervening or superseding cause, but I think in the end a jury would say,
Well, you don't even get to a jury probably. I mean, isn't it the difference between getting a motion to dismiss granted and a motion for summary judgment granted?
Probably.
That's the difference between a cause of action that exists but is non-meritorious and possibly ditchable on summary judgment or after jury verdict versus one you can't even, might as well not bother filing.
Exactly. It's an interesting question, but I don't know if the law still has a strict cutoff in that causal period.
Counsel, you're out of time, but we've used up a lot of your time with our questions. Would you like 30 seconds to wrap up?
You know, I again, as I said earlier, in an area of common law, which this court is well equipped to handle, in the case when this court, in an area where this court has been very patient with the legislature, and in an area where we have a common law immunity that makes no sense anymore and that only applies to one class of defendants, the time has come to abolish that immunity. And thank you for your time.
Thank you, counsel. We thank all counsel for their arguments this morning. Court will take this matter under advisement. This time.